Hi friends, this is CA Harsha. Recently on this 24th April 2025, the famous doctrine called Doctrine of Basic Structure and the famous Supreme Court judgment, that is the Keshwananda Bharati versus State of Kerala, had completed 52 years. So on this occasion, I just want to share my understanding with you all about this. I want to share my understanding on this doctrine of basic structure and the Keshwananda Bharati case with you all. So for that reason, I am making this video. Now, for understanding this doctrine of basic structure, we should have to also have to analyze few Supreme Court judgments, a series of few Supreme Court judgments, and also few constitutional amendments. So in that, the Supreme Court judgments which we have to analyze was the Kameshwar Singh versus State of Bihar, and also the Shankari Parsad versus State of Bihar, and the Sajjan Singh versus State of Rajasthan, and also Goleknath brothers versus State of Punjab, and finally the Keshwananda Bharati versus State of Kerala, and also the first constitutional amendment, fourth constitutional amendment, and 17th constitutional amendment. Fourth and 17th you need not to worry much. Only first constitutional amendment we have to consider more. Now, so these aspects will try to cover in this video, and starting will start now. Coming to the analysis, the first case that which will start was the Kameshwar Singh versus State of Bihar. Now before going into this case, I just want to highlight article 13.2. So article 13.2, the understanding of article 13.2 is very important to have a clear cut understanding of this doctrine of basic structure. Now if you see here, we are I'm referring the article 13.2. So if you refer here, this is the original manuscript of the constitution, because by the time this case had happened, there were no amendment made in the constitution. So that's why now whatever the constitutional copies which are available in the internet today, majority of them are post amendment and considering few amendments. So that's why I've taken the screenshot directly from the original manuscript of the constitution. Now if you refer article 13.2, uh, what it is saying was, any law enacted either by the parliament or either by the state assemblies should not take away or abridge means restricting the scope. So any law should not take away or should not restrict the fundamental rights provided to me by the constitution. What if that enactment or law takeaways or abridges the fundamental rights? That law itself will be held void to the extent of the contravention. That law will be held void. This is what article 13.2 is saying. The understanding of article 13.2 is very much required for the understanding of this entire concept. Now going to the Kameshwar Singh case. Now the facts of the Kameshwar Singh case were very simple. It happened in the year 1951. So hardly by the time we have completed 1 year of the no adoption of the implementation of the Constitution of India. So now we all know that during the British era there was a system called Zamindari system. In that Zamindari system, large parcels of the lands are with no few individuals. Now once the republic government has been formed after elections and all, the state assemblies or the, as land is a subject of state, so majority of the state assemblies came up with the Land Reforms Act. Now, the objective of this Land Reforms Act was to, whatever the huge land parcels getting accumulated with few individuals, that they want to the government want to take it from that individual. Say for example, we call it as ceiling limit. Say 30 acres or 40 acres is the ceiling limit which I will announce, and beyond that whatever is there, that you have to hand over to the government. Now what government will do, government will use it for the benefit of the general public, or I will distribute it for the poor in a whatever the better way. So this is what the objective or idea behind all this Land Reforms Act. Now one of that Land Reform Act was this Bihar Land Reform Act. Now here the person, Mr. Kameshwar Singh. Now this Kameshwar Singh is a landlord or a zamindari. Now he went to the Supreme Court stating that whatever the Bihar Land Reform Act is there, that Bihar Land Reform Act is violating the fundamental rights granted to me under Article 14, Article 19, and Article 31. So these are the three articles which the Bihar Land Reform Act is violating, is what his argument or contention was. Now we'll analyze how it is violating Article 19. Now, if you refer the Article 19, in this article also they are specifically referring to clause F. Article 19, all citizens shall have the right to acquire, hold and dispose of property. Now, what Article 19 subclause F is saying that every citizen, means Kameshwar Singh also is a citizen here, I have the right to acquire and hold the property. But now through Bihar Land Reform Act, you are saying that no, you can't hold beyond 30 acres or you can't hold beyond 40 acres. You are violating, or you are taking away, or you are abridging my fundamental right. This is one point. The other one was violation of Article 14. Now, the Bihar Land Reform Act is violating Article 14 was, now this Bihar Land Reform Act had classified Jamindars into different groups for the purpose of calculating the compensation. Now, all of us are Jamindaris only. All of us are equals. You treating equals unequally, thereby it is violation of Article 14 is what one point. One point of argument by the petitioner, that is Kameshwar Singh. The other one was Article 31. Now, what Article 31 is saying that no property, movable or immovable, acquired for public purposes under any law, authority, the taking of such possession or such acquisition, unless the law provides for compensation. Now, what it is saying was, whenever the government is acquiring any immovable or movable property for public purposes, then it should have to provide some compensation to that person, and that compensation should be tangible, real. It should not be some illusionary. That compensation should have to be real. Now, here the argument of Kameshwar Singh was, there was no proper compensation provided to me at the time they are acquiring that land. So this is what the three arguments or contentions of the petitioners. Now, what Supreme Court had analyzed, and what was the conclusion they came, we'll look into it now. Now, we'll again go back to Article 19 itself. So, Article 19, as I said earlier, that it is taking away or abridging my right of holding the property, which is a fundamental right. Now, what the revenue or the government had submitted to the court was that there was Article 19.5. Now, if you refer Article 19.5, what it is saying was, clause DEF. I'm putting it in a simple way for better understanding. Clause DEF will not affect the operation of law even if it imposes restrictions on the exercising of the rights, if that restrictions are imposed in the interest of general public or for the protection of interest of the scheduled tribe. Simply speaking, now the Bihar Land Reform Act is there, that the Bihar Land Reform Act is putting restriction on my fundamental right, that is to hold the property. Now, this restriction, why I am putting this restriction, I am putting to achieve a in the interest of the general public, I am putting this restriction. Through this restriction, what I am doing, I am taking some land from you, and that I am using it for the general public welfare. It is in the interest of general public. Thereby, the restriction, whatever the restriction you are saying, whatever what your contention of saying that they are taking away or they are restricting my fundamental right will not apply, because this is clearly said in Article 19.5. I hope this is clear. So, the argument of the petitioner that the Bihar Land Reform Act is taking away or abridging my fundamental right under Article 19 is not acceptable, because here the Constitution itself is permitting that your fundamental right under Article 19 subclause F can be restricted in the interest of general public, to achieve something in a greater large, to achieve something which is very much required for the general public. I can put some restrictions on your fundamental right, is what uh, categorically coming through article 19.5. So that is why this argument is not acceptable. But coming to article 14, the Supreme Court had agreed to the arguments of the petitioner. And also importantly here, not article 14, in my understanding article 31 is one of the important aspect the Supreme Court had considered. Excuse me. Now coming article 31, if you see what the Supreme Court had said was, whenever you are acquiring any property for public purposes, you have to provide compensation. This providing compensation should be real and tangible. It should not be illusionary. It should not be illusionary. Proper compensation should have to be provided. If you are not providing proper compensation, it is violation of article 31. As it is violating article 31, I am once again taking you back to the article 13 too. As of now, our analysis, what it is saying was, article 19 it is not violating, but article 14 and article 31 it is violating. Why it is violating article 31? Proper compensation. Compensation in the sense, not namesake compensation. Here, even in this case, the Supreme Court had held that excuse me, Supreme Court had held that compensation should be real. Compensation should not be illusionary. And also Supreme Court said that we will review the compensation provided to you. We will review the compensation provided. The compensation provided should have to satisfy us that this is a reasonable compensation provided. So that is why here in this case, as the Bihar Land Reform Act is not providing proper compensation to the zemindaris on or landlord, it is violating article 31, and also treating equals unequally, it is violating article 14. Now Bihar Land Reform Act, being a law, is taking away or abridging my fundamental rights provided under article 14 and article 31. So will it hit article 13 too? Yes, definitely it will hit article 13 too. So what article 13 is saying? Article 32 is saying that any law, if it is taking away or abridging your fundamental rights, then that law itself will be void. So thereby the Supreme Court had said that to the extent of these provisions, the Bihar Land Reform Act is void. So this is what the conclusion of the Supreme Court in the Kameshwar Singh case. So I hope this is clear up to here. Now this is clearly going against to the government, and government had a big blow on this based on this judgment. Now what immediately government had done was, to neutralize this judgment, they came up with the first constitutional amendment. Now through this first constitutional amendment, what the government had done was, they have inserted article 31A and article 31B. Till now we had only article till the time first constitution amendment had brought, there were only article 31. There is no A and B. The article 31A and B were brought into the constitution after this through this first constitution amendment. Now if you refer, I have brought the text also here, exact extract of article 31A. If you observe here, no law providing for the acquisition by the state, no law providing for the acquisition by the state of any estate or of any rights be void on the ground that it is inconsistent or takeaways or abridges any of the rights conferred by article 14, 19 or 31. Now what it is saying that, now onwards, any state land reform act, even though it is violating article 14, 19 and 31, it shall not be held void. It will be valid only. So Bihar Land Reform Act, AP Land Reform Act, any land reform act, even if it is taking away or abridging my fundamental rights which is provided under article 14, 19 and 31 will be still valid only. It is getting immunity from article 13 to via new article inserted, that is article 31a. Now article 14 and article 31 we have discussed it. In Kameshwar Singh also it is there that the Supreme Court had also concluded that the Bihar Land Reform Act is violating article 14 and article 31. Now why they have covered article 19? Because not only in the state of Bihar, there are number of disputes happening in and around in different states. To get immunity from all the cases, they have made this amendment and they have included article 19 also. So now final conclusion through this article 31a was that even if the law for the acquisition by the state of any estate or any rights, so in this context they are saying that, so even if you consider the Bihar Land Reform Act, even though it is going that law, generally law, if any law is going against if any law is taking away or curtailing my fundamental right, which will hit 13.2 will hit. Once the 13.2 hits, it will become void. Now that immunity from getting hitted by 13.2 is provided by 31a. 31a is saying that no, even if you are violating these three articles also, not a problem, you will be still valid. It is simply speaking, even if you are violating these three articles also, even if you are taking away or curtailing these three articles also, not a problem, you will be still valid, is what the 31a is saying. Now 31b, it is a very important article. By what I say, in my personal view, fortunately 31b is not effective today. So it was a very aggressive view in my view. I don't know whether this giving these words is proper or not, but what article 31b says, that article 31b had introduced a new concept called ninth schedule to the Constitution of India. Now what is this ninth schedule? Say let us assume I am state of Andhra Pradesh. I have drafted one legislation. I have enacted one legislation which had the governor also given approval and it is enacted. Now if the parliament agrees to keep this legislation under ninth schedule, then the courts cannot touch that act. Courts cannot touch in the that act, in the sense court cannot, there cannot be any judicial review on that judgments in the context of fundamental rights. Even if that act is violating the fundamental rights, judiciary can't do anything. So this is the level of aggressiveness that was there in the ninth schedule. So but however, till today there is no any ninth schedule. Subject to correction, I think from 1978 onwards or 1971 onwards, this ninth schedule concept has been completely removed. So why they have introduced this ninth schedule was, if you remember, while concluding the Kameshwar Singh case, I have said that the court had said that we will review the compensation provided to you. We will review, because the compensation is a fundamental right. Whether your fundamental right has been properly safeguarded or has been properly given to you or not, we will review. This is nothing but judiciary review. We will review is what the court had said. Now Bihar Land Reform Act, I put it in the ninth schedule. Can the judiciary come and review the compensation which I have provided? The answer is no, because it was there in the ninth schedule. Who is saying that if any enactment is there in the ninth schedule, that judiciary can't come and touch, in the judiciary can't come and review whether the whether any fundamental rights are being taken away or abridged? It is article 31b is saying that. So simply speaking, if any enactment is stated in the ninth schedule, whether even though it is violating the fundamental rights, the judiciary cannot do anything, is what the crux of article 31b. So article 31a and article 31b are the outcomes of the first constitutional amendment. Not only these two articles, there are some other articles also. At the time there was one famous another Supreme Court judgment also, that Champakam Dorairajan versus state of Tamil Nadu. That judgment also nullified or neutralized by this first constitutional amendment. But anyway, that was not the subject matter of our discussion. So that's why I'm not bringing that thing. So to this subject matter, these are the two relevant amendments which was covered under the first constitution amendment. So this is what happened. Now government is happy. Whatever the negative aspects is there in the judgment, that were covered or rectified through this first constitution amendment. Now here comes the another case, second case into the picture, that is Shankari Prasad versus State of Bihar. Now this Shankari Prasad versus State of Bihar is a very important case for our understanding purpose. There is no because here comes the to ultimately to appreciate the concept of basic structure. Our understanding of the Shankari Prasad case is very important. Now Shankari Prasad, he went to the Supreme Court challenging the validity of the first constitution amendment. Challenging the validity of the first constitution amendment. Now what are his major points? If you there are two major points. Now the two major points was, there was a question that whether the parliament can alter or take away or change the fundamental rights. Whatever the fundamental rights are there in the constitution, whether that can be taken away, whether that can be abridged, or whether that can be altered by the parliament. Do parliament has that power, is one aspect of point to be considered in Shankari Prasad. The other one was whether the constitution amendment is a law under Article 13(2). Now, why this question is arising because through constitution amendment I am changing the fundamental rights, or I am taking away the fundamental rights. Now, if the constitutional amendment is a law under Article 13(2), then I cannot change the fundamental rights. So that is the reason why one point of analysis in this Shankari Prasad case was whether the constitution amendment is a law as per 13(2). The other one was, do parliament has the power to keep restrictions or abridging means, once again saying, restricting the scope of the right. Removing or changing the fundamental rights, can the parliament has that power? These are the questions or analysis part in the Shankari Prasad case. Now what the Supreme Court had said was, now this part is very crucial. Now in general, in constitution there is an article called Article 368. Article 368 deals with the constitution amendment procedures. Now while analyzing this part, the Supreme Court had said that parliament has two types of powers when it coming to law enactments and constitution. One is the ordinary lawmaking power. One is the ordinary lawmaking power. The other one is the constituent power. Now, what is this ordinary lawmaking power and what is this constituent power means? See, the constitution was prepared and adopted by the Constituent Assembly. There is a body called Constituent Assembly, not body, a similar kind of parliament thing where Dr. B.R. Ambedkar, all these persons are there. This Constituent Assembly had been, the purpose of the Constituent Assembly was to draft the constitution, discussing, debating, and giving a proper constitution for the country to be implemented. This is what the job that has been done by the Constituent Assembly. Now what the Supreme Court had said that parliament has two types of powers. One is the ordinary lawmaking power and the other one is the constituent power. Now this constituent power is similar to the power of that Constituent Assembly. Now once the constitution came into force, the Constituent Assembly had closed. Now it was only completely parliament. Now what the Supreme Court analysis was, that Constituent Assembly related power. Now the job of the Constituent Assembly was to make changes to the constitution, develop the constitution and also make changes. Now anyway, what the Supreme Court had said that as parliament came into the picture, parliament still have the power of the parliament still has the constituent power through which they can do the constitutional amendments, and parliament also has the ordinary lawmaking power which is coming through general articles like Article 245, Article 246 and all. Now what the Supreme Court had brought was, parliament has two kind of powers: ordinary law making power, which is coming through article 245, 246 and all, and also the constituent power, which is coming through article 368. Now, as if you consider the fact that the parliament is having the constant power, now what is the purpose of the constant power? The purpose of the constitution power, constant power was to make changes, or make changes to the constitution, or to draft the constitution. If that power is there to me, can I make changes to the constitution? Can I make changes to the, it is me as good as subsuming the role of the constituent assembly. Now, if I subsume the role, or if I sit in the role of the constitution assembly, obviously I will get the power or authority to draft the constitution, or to make the change, or make changes to the constitution. Thereby, the parliament can alter, take away, or make changes to the fundamental rights, is what the conclusion of the Supreme Court in the Shankari Parsad case. So Shankari Prasad, in Shankari Prasad case, what the Supreme Court had accepted, that the parliament has ordinary law making power, which is a separate, which is one leg, and the other leg was the constant power. Through constant power, yes, by using constant power, yes, I can change the fundamental rights, I can take away the fundamental rights, is what the Supreme Court had also accepted. Now, coming to the other question, that whether the constitution amendment is a law under article 13(2). Now, for this the answer was, if I am drafting any, if parliament is enacting any law by using the ordinary law making power, then it will be covered under article 13(2). The moment parliament is making any law by using the power under article 368, that is the constant power, constant assembly power, or constant power, it cannot be called as a law, it cannot be called as an ordinary law. Simply speaking, the Supreme Court had said that whatever the general legislations I am doing, like income tax, GST, customs, all these things will be an ordinary laws, that will be covered under article 13(2). But the constitutional amendment acts which I am doing, for this I am not deriving the power from general articles like article 245, article 246. I am deriving power specifically from article 368, which is of the constant power. As I am not deriving the power from the ordinary lawmaking power, the constitution amendment act cannot be an ordinary law, thereby it will not fall under article 13(2), is what the Supreme Court analysis was. Now, the final crux of this Shankari Prasad case was, one thing was, constitution amendment act is not an law, not an ordinary law under not an ordinary law which will be covered under article 13(2), because the power to make the Constituent Amendment Act is not coming to me through a normal lawmaking power. It is coming to me through a special power of making changes to the constitution. Thereby, it will not fall under. It will not be called as an Constitution Amendment Act. Will not be an ordinary law. Thereby, the moment it is not an ordinary law, it will not get hit by Article 13(2). The moment it is not getting hit by Article 13(2), I can amend the, or I can change the, or I can abridge the fundamental rights. So this is what the conclusion of the Shankari Prasad case. I hope this is clear up to here. Now, coming to the next aspect, there was also another. Now, till now the status was, the Shankari Prasad case was there in the favor of the government, because, as I said, the Constitutional Amendment Act is not an ordinary law. Thereby, it can take away, or it can violate, or it can abridge the fundamental rights. And also, the parliament can parliament can make changes to the fundamental rights, because it is also having the constituent power, which is similar to the constituent assembly. It means that they can make changes to the constitution, or all these things as we discussed. Now, there is now again after this, now the status of Shankari after the Shankari Prasad case, it was all in favor of the government. Now again there came in another case called Sajjan Singh versus State of Rajasthan 1964. Now this is also a similar case. All the arguments or the judgment of Shankari Prasad was upheld by the Supreme Court in the same case, that is Sajjan Singh versus State of Rajasthan. The arguments were upheld, and even in Sajjan Singh case, they have said that the parliament, the power of parliament to make changes to the constitution is unlimited. Even they have said this, but the only point to be noted in Sajjan Singh case was the minority judgment in the Sajjan Singh case. The minority judgment in the Sajjan Singh case had indirectly given a hint that there are some elements, some basic terms of the constitution which cannot be changed, this is the first point of line, uh, or to say the first birth point of the doctrine of basic structure. For the first time it has been indirectly used in the minority judgment of the Sajjan Singh versus State of Rajasthan. There were nothing new things in this Sajjan Singh versus State of Rajasthan except what I have just now stated. The next case was the Goleknath versus State of Punjab. This is an very important judgment. Here the view has been completely changed. Now how it got completely changed is what we will try and understand. Now Goleknath versus State of Punjab 1967 is the year of the case. In this case, what happened was Goleknath is also a landlord, Goleknath brothers. They have challenged the first constitutional amendment, fourth constitutional amendment, and 17th constitutional amendment. So they went to the Supreme Court. Now, just now in Shankari Prasad, I have concluded that the constitutional amendment, say, let us assume if I prove that the constitutional amendment is also an ordinary law, can it take away or can it abridge the fundamental rights? No, it cannot do that. So the constitutional amendment got an relief only because of Supreme Court recognizing or Supreme Court saying that the parliament has two kinds of power, that is ordinary law making power and constituent power. Constituent power I can't I can't no control through the constitution, because it is as good as the power of the constituent assembly. So they can, using that route, they can change many things in the constitution, is what the Supreme Court had agreed. Now the only way for Goleknath brothers or Goleknath to get a favorable judgment in this case was they should be successful in establishing that no, parliament doesn't have two kinds of powers. They have only one power, that is ordinary lawmaking power. They don't have the constituent power. As they don't have any constituent power, they can't make the changes in the way, or the parliament doesn't have unlimited powers to make changes to the constitution, as they doesn't have the constant power. If this point Goleknath brothers can put before the court and get the uh, acceptance of the court, then they would the view of the court could can change. So this is what exactly happened in the Goleknath case. Now what change they have brought was, they have clearly read the article 368 and they have uh, put forth before the Supreme Court that nowhere in the article 368 it has mentioned the word power. It had mentioned only the word procedure to be followed for the constituent amendment. So what they are trying to say by highlighting that nowhere the word power is used means the power to make the constitutional amendment is also coming from the normal articles like article 245 and article 246 only. The power is getting from only one or two articles only. Only what article 368 is saying was, article 368 is only giving the procedure, it is not giving the power. So if you refer the exact extract portion which I have extracted here, if you observe the wordings here, procedure for amendment of constitution, nowhere it had referred the word power. And even if you refer the text of Article 368 also, nowhere the word power is used. It means that for making the Constitution Amendment Act, Parliament doesn't have any specific power in Article 368. It is only procedure mentioned. Then where the power is getting? The power is getting from the normal articles only, like as I said earlier, Article 245 and Article 246 only. There is no any specific article which is giving specific power for the Constitution Amendment Act. Thereby, Parliament is having only one power, that is normal lawmaking power. And in this power I derived, but the procedure I am going to Article 368. For normal lawmaking process and for constitutional amendment act, I am deriving power only from one source, but the routes to be followed I am just referring Article 368, because it has specifically mentioned the procedure but not the power. Thereby Parliament is having only one power. They don't have the constant power. The moment I don't have the constant power, as I stated earlier, I can't make changes. I can't. I don't have unlimited powers to make amendments to the constitution, and also as the power is not getting derived specifically, or I will put it in this way, that would be better. As the Constitutional Amendment Act is deriving power from the normal lawmaking process, the Constitutional Amendment Act is also a normal law. The moment it is a normal law, it will covered under Article 13.2. The moment it covered under Article 13.2, I cannot take away or I cannot abridge the fundamental rights. It means that my fundamental rights which has been given in the Constitution are sacrosanct. Those are final. This cannot be changed. This is what the judgment came in the Goleknath versus State of Punjab. So, to summarize in a simple way, the if you read once, I will show this extract also. I will put this extract. So, an amendment of this constitution may be initiated only by the introduction of a bill for the purpose in either house of parliament, and when the bill is passed in each house by a majority of the total membership of that house, and by a majority of not less than the two-thirds of the members of that house present and voting, it shall be presented to the president for his assent upon. So nowhere the word power is used. It means Article 368 is only saying that the procedure power is a normal lawmaking power only is there for the parliament. Parliament is having only one power, normal lawmaking power. But for constitutional amendment, I am following a separate procedure route. So all the favorable things which were came to the government in the Shankari Parsad case or Sajjan Singh case has been completely disappeared in the Goleknath versus State of Punjab case, where the Goleknath brothers had successfully established the fact that Parliament is having only one power, which the Supreme Court had also accepted. So this is a situation. Now it completely changed against to the government. Will government be silent? No. So government came up with 24th Constitution Amendment Act. Now through this 24th Constitution Amendment Act, what government had done was, they have made amendment to Article 13 and also Article 368. Why they have made amendment to Article 13? Now the constitutional amendment is getting covered under Article 13. So as it is a normal law, it should not disturb my fundamental rights. If it disturb my fundamental rights, that will also be void. So I can't make changes to the constitution itself. So that's why what government had done, they made amendment to Article 13, and also they made amendment to Article 368. Why they made amendment to Article 368? Because they want to once again through this amendment they will establish that no, Article 368 is not saying only procedure, it is giving power also. Now if you read the wordings of the Article 368, power of Parliament to amend the constitution and the procedure thereof. Notwithstanding anything in this constitution, Parliament may, in exercise of its constituent power, amend by way of addition, by way of addition, variation, or repeal any provision of this constitution in accordance with the procedure laid down in this article. Now, if you observe here, notwithstanding anything in this constitution, Parliament, in exercise of its constituent power. Constituent power means, as I said earlier, it is the as good as the no power which is relating to the Constituent Assembly, so that I can make changes to the make changes to the constitution, same as like the Constituent Assembly. It means that whatever the Goleknath brothers had established, that whatever the power Parliament is not having, they have brought that power through this 24th Constitution Amendment by making changes through the to the Article 368. Now the word it got changed to power of Parliament. Earlier, if you refer, it is only procedure for amendment of Constitution. Now it got changed. The wordings got changed to power of Parliament to amend the Constitution and procedure thereof, and also notwithstanding anything in this Constitution, Parliament may in exercise of its constituent power. So it is clearly bringing that no, not only ordinary law making power, I have this constituent power also, is what they are bringing. And now what article through Article 13, what they are saying, nothing in this article shall apply to any amendment of this constitution made under Article 368. Now, two-way protection they have taken completely to safeguard. Now, even if my constitution amendment, if someone say that no, it is still an ordinary law only, you are still violating the fundamental rights, then to counter that, the revenue or the government will show this provision stating that nothing in this article means the entire Article 13 will not apply to the amendment made to this constitution. So this is how again government through the 24th Constitution Amendment had brought things into their favor. Now, will there be a silence from the landlords or other things? No, there will not be any silence. Now, again, there came in another case called Keshwananda Bharati versus State of Kerala. This is a very famous judgment which put an end to this race between the legislature and the judiciary. So this Keshwananda Bharati versus State of Kerala had put an end to the to this dispute point, and the Keshwananda, not only the Keshwananda Bharati case, I just want to take up the some of the arguments or points referred by the great advocate Nani Palkiwala also. So the Keshwananda Bharati, what were the analysis of the Keshwananda Bharati, and also few points of the advocate or legendary person Nani Palkiwala will be covered in another part of this evaluation of the basic structure video series that will come as another part. Hope this is clear. So thanks for your listening, and I would like to give credits to Babu Gunashekar and a UPSC mentor. So majority of the contents has been taken from his lecture. I would like to acknowledge the or thank him to this all these things which helped me in a very clear cut understanding. So thank you all.